In this segment, we will cover three such essential dimensions. One, core principles of responsible reporting. First, let's delve into the core principles that form the backbone of ethical journalism: accuracy, fairness, and accountability. Accuracy is the foremost pillar of responsible reporting. It requires that every fact, figure, or statement published be verified before it reaches the public. In the context of legal proceedings, errors can lead to misinterpretations that not only tarnish reputations but also potentially influence judicial outcomes. Imagine a situation where an unverified detail appears in a headline. A single inaccuracy can initiate a cascade of public information that might impact the presumption of innocence. It is essential that every report be cross checked against reliable sources and verified with the utmost diligence. Fairness necessitates an unbiased presentation of information. It involves giving equal weight to multiple perspectives and ensuring that the right of both the accused and the victim are respected. In high profile cases, the temptation to sensationalize can lead to an imbalance where one side is unduly favored, distorting public perception. By adhering to fairness, journalists safeguard against generating undue prejudice, thereby upholding the principles of impartiality that is critical to a fair trial. Accountability holds journalists and their organizations responsible for the information they disseminate. This means acknowledging and correcting mistakes promptly, explaining editorial decisions when challenged, and being transparent about potential conflicts of interest. Accountability builds public trust and ensures that the media remains a credible source of information, even in challenging scenarios. When accountability is sidelined, the risk is not only the erosion of trust, but also the potential for harm to individuals involved in legal processes. Let's reflect for a moment. Any deviation from these principles, whether through hasty reporting or bias, can distort justice. Let's ask ourselves, how often might a lapse in verification or fairness have altered the course of public opinion before a trial even begins? Next, we turn to editorial oversight, a critical mechanism designed to serve as a final filter before news reaches the public. In an ideal setting, editorial boards function as gatekeepers, ensuring not only content meeting high ethical standards is published, they review stories meticulously for accuracy, context, and fairness. This level of scrutiny is essential, particularly in legal matters where speculative or unverified reports can have lasting repercussions. However, the reality is often more complex. With the increasing competition for high ratings and online engagement, some media organizations might prioritize sensationalism over sober reporting. When the drive for engagement overshadows editorial judgment, the result can be exaggerated headlines, unchecked speculation, and biased narratives. We shall explore several examples where effective editorial oversight has prevented these pitfalls, as well as cases where a lack of oversight led to detrimental sensationalism that skewed public understanding. Look at instances where responsible editorial practices have not only maintained accuracy but also enhanced the credibility of the media outlet. Conversely, consider cases where a lack of oversight resulted in headlines that misled the public, sometimes with serious consequences for the individuals involved. These examples provide a contrasting view, helping us understand the real world impacts of editorial decisions. We shall ask ourselves, how might stronger editorial oversight affect both the quality of reporting and the fairness of legal proceedings? Where should media organizations draw the line between attracting viewership and upholding their duty to report responsibly? Finally, high profile cases bring forth unique ethical dilemmas that challenge even the most seasoned journalists. When cases capture public attention, the pressure to deliver continuous updates can lead to the temptation of publishing speculative details. Should a media outlet report a rumor if it might prompt a swift public reaction, even if it could be prejudicial? There is an inherent dilemma here. While the public has a right to be informed, the media must ensure that its reporting does not compromise an ongoing trial's impartiality. There lies a perpetual tension between serving the public's right to know and protecting the judicial process from bias. For instance, should an outlet cover unverified details that would influence jury pools or witness testimonies? Through real life examples, we shall see that even well intentioned reporting can inadvertently skew perceptions, thereby affecting the fairness of the trial. It's always an ethical challenge that arises when journalists discover information that, if published, could bring significant public interest, but may also cast doubt on the integrity of the judicial process. In such instances, decision makers in the newsroom must weigh the potential benefits of public awareness against the risk of influencing a trial outcome. To sum up, the ethical responsibilities of journalism are not merely guidelines, but essential tenets that uphold the integrity of both the media and the judicial system. By adhering to the core principles of accuracy, fairness, and accountability, exercising rigorous editorial oversight, and navigating ethical dilemmas with caution, the media can honor its public duty without compromising the sanctity of a fair trial. I invite you all to reflect on these issues as we move forward. Where exactly should the line be drawn between serving the public's right to know and protecting the procedural rights of the accused? Next, we shall assess the regulatory mechanisms that are designed to curtail media excesses, ensuring that reporting does not interfere with the fairness and integrity of judicial proceedings. In this segment, we will discuss three major areas. One is Contempt of Courts Act 1971. This act was enacted to preserve the dignity and authority of the judiciary by preventing any publication or conduct that may interfere with or prejudice ongoing judicial proceedings, referring to the media trials. The Act criminalizes publishing or broadcasting any material that can be seen as prejudicial to a fair trial. It empowers courts to take action against those whose writings or broadcasts could potentially influence the outcome of pending cases. Over the years, the Act has been invoked in several instances to curb sensational reporting that risk distorting the judicial process. For example, when media reports veer into speculative territory by divulging unverified details or commentary that could sway public perception, courts have at times issued contempt notices against individuals or media organizations. However, while the Act has served as a crucial deterrent, challenges arise with the advent of digital media. The speed and reach of online platforms can overwhelm traditional legal remedies. Social media channels often allow rapid dissemination of content that might bypass traditional checks, making it difficult to enforce the Act consistently across digital spaces. As a result, critics argue that the Act in its recent current form may be inadequate in addressing the complexities of digital communication. Now we shall reflect, or you should think about how effectively can the Contempt of Courts Act balance the protection of judicial processes with upholding free speech in today's hyper-connected digital era. Next, we consider the role of Press Council of India. The PCI has long been at the forefront of setting ethical standards for journalism in India. The PCI has established comprehensive guidelines that outline responsible reporting, particularly in matters that involve sensitive legal cases. These guidelines emphasize the need for accuracy, fairness, and restraint, advising media outlets to refrain from publishing speculative or prejudicial comments, especially when a case is sub judice. In high-profile cases, the PCI guidelines serve as a benchmark for media conduct. When responsibly followed, these guidelines help ensure that the press maintains a balance between informing the public and respecting the judicial process. However, enforcement is largely self-regulatory. This means that while many media organizations strive to adhere to these standards, there are cases where the pressure for sensationalism leads to lapses, with some outlets deviating from these principles. The effectiveness of these guidelines is often contingent on the witnesses of media organizations to self-police. In instances of extreme competition or in the race for higher ratings, commercial interest may override ethical considerations, leading to publication of content that undermines public trust in both the media and the judicial process. Are self-regulatory mechanisms such as these provided by the PCI sufficient to ensure responsible reporting, especially in an era when digital competition can incentivize ethical compromises? That is one question to think about. As digital media platforms have become ubiquitous, new regulatory instruments have been introduced to address emerging challenges. Among these are the Cable Television Networks Regulation Act and updated IT rules. The Act provides a framework for regulating television content, including news broadcast. It aims to prevent the dissemination of material that could adversely impact public order or impede judicial processes. Though traditionally focused on cable networks, its principles are increasingly being invoked to monitor televised media, ensuring a degree of restraint in reporting on ongoing cases. The IT rules, which govern online content and digital platforms, represent a modern attempt to bridge the regulatory gap in the digital age. These rules impose certain obligations on social media platforms and online news portals, including the removal of content that violates guidelines on prejudicial reporting. However, given the vast and decentralized nature of digital media, the enforcement of these rules faces significant hurdles. While these modern regulatory measures are steps in the right direction, they are not without criticism. Their scope and reach often lag behind the rapid evolution of digital technology. Moreover, debates continue over their potential impact on free speech. Some argue that overly stringent controls could stifle legitimate reporting and commentary. Many stakeholders, including legal experts and media professionals, call for continuous revision of these regulatory frameworks to ensure they remain effective and relevant. This includes proposals for clearer definition of prejudicial content and stronger enforcement mechanisms that can operate efficiently in the digital space. But does existing laws and guidelines suffice to manage today's complex digital landscape? Or have they become outdated in the face of emerging technologies? How might further reforms ensure a better balance between curtailing media accesses and protecting free expression? As we assess these regulatory mechanisms, the Contempt of Courts Act, PCI guidelines, and modern digital regulation, it becomes evident that while they serve important functions in mitigating the adverse effects of media trials and excesses, there remains a significant gap between traditional regulatory frameworks and the challenges posed by the digital age. This gap invites us to continually reevaluate and update our laws and guidelines. Our reflection today is critical in asking, are these measures sufficient to protect the sanctity of the judicial process? Or must we innovate further to address the speed, reach, and nuance of digital media? The answer to these questions will ultimately shape the future of both media regulation and judicial integrity in India. In the final portion of this segment, we address the regulatory gaps, enforcement challenges that persist despite the existing rules and guidelines. We shall focus on three areas. One is, first, we must confront the reality that despite an array of regulations, enforcement remains one of the most daunting challenges. Instances of unchecked media behavior. There have been numerous situations where sensational or prejudicial reporting has gone unchecked. Monitoring and enforcing regulations often lack the resources or the technological tools needed to keep up with the rapid pace of digital information dissemination. In today's globalized media environment, content can be published instantly from any part of the world, complicating enforcement efforts by national regulators. Legal languages sometimes fall short in clearly defining what constitutes prejudicial reporting or overstepping the bounds of responsible journalism, thereby leaving enforcement to subjective interpretation. So how might these enforcement gaps be effectively addressed, and what role does clarity in legal definitions play in strengthening regulatory outcomes? Next, we need to examine the interplay between self-regulation by media entities and government-imposed statutory regulations. Many media organizations have their own internal standards and editorial oversight committees intended to ensure responsible reporting. Regulation offers flexibility and can often be more responsible than bureaucratic processes, allowing outlets to quickly correct mistakes and adhere to ethical norms. What are the merits of it and drawbacks? The merits are, and it encourages innovation and ethical commitment from within the media community. It fosters a sense of accountability that is proactive rather than punitive. And what are the drawbacks? Self-regulations may lack the force of law, leading to inconsistent application across different organizations. In highly competitive environments, commercial pressure may weaken self-imposed standards, leading to over-reliance on sensationalism, government-imposed controls. Statutory regulations through laws like the Contempt of Courts and IT rules provides a legal framework to penalize irresponsible reporting. However, these measures carry the risk of excessively stringent controls might stifle journalistic creativity and impede the press's watchdog role. There is a fine line between protecting judicial integrity and curtailing freedom of expression, with enforcement sometimes tipping into censorship. Challenge is to achieve a balance where media organizations are encouraged to self-regulate robustly, while statutory mechanisms remain in place as a safeguard against the most egregious violations. Let's consider, could joint oversight committees or collaborative regulatory frameworks between the state and media organizations help foster a more balanced environment? Finally, let's broaden our perspective by considering the viewpoints of various stakeholders who are intimately involved in this dynamic. Legal experts, many legal professionals advocate for clearer statutory definitions and better coordination between judicial bodies and regulatory agencies to ensure that media reporting does not impede judicial processes. They often emphasize that while some degree of media freedom is indispensable, there must be enforceable limits when reporting becomes demonstratively prejudicial. Second, media professionals, on the other hand, journalists, media executives stress the importance of protecting the freedom of press. They argue that overly strict government controls can lead to self censorship, hampering investigative journalism that plays a vital role in uncovering corruption and injustice. Their perspective often highlights the need for ethical training, robust internal oversight, and industry wide best practices. Third is civil society representatives. Advocates from civil society typically support measures that guard the rights of the public to receive accurate information, while simultaneously protecting individuals from wrongful prejudice. They call for transparency, fairness, and balanced enforcement of regulations, ensuring that both the press and the judiciary operate in public trust. By integrating these diverse perspectives, we can identify common ground and work towards solutions that address the shortcomings of current regulatory frameworks. How might collaborative platforms involving government, media, and civil society lead to innovative approaches that optimize both free expression and judicial integrity? As we conclude this segment, reflect on these fundamental issues. Despite the existence of several regulatory mechanisms, significant enforcement challenges persist. The interplay between self regulation and statutory control highlights both the strengths and weaknesses of our current system. By engaging with stakeholders across the board, legal experts, media professionals, and civil society, we can envision a path forward that balances necessary oversight with the freedom essential in investigative journalism. With these reflections, we are now set to the stage for a broader comparative analysis. I'll look at how other legal systems grapple with similar challenges and what lessons can be learned to further refine our regulatory framework. Let's move beyond our borders and examine how international jurisdictions confront the challenges of media trials. Now, we broaden our perspective by examining judicial responses to media trials in other jurisdictions. We will concentrate on two major legal systems, the United States and the United Kingdom, and briefly review practices in other common law countries like Australia and Canada. This comparative analysis will help illuminate different approaches to balancing press freedom with the right to a fair trial, providing valuable insights for our own system. In the United Kingdom, the judiciary has established a robust framework designed to ensure that media reports do not interfere with the ongoing judicial proceedings. The UK legal system places significant emphasis on maintaining the integrity of a trial, and this is reflected in strong contempt of court provisions and rigorous judicial oversight. The UK's stringent contempt of court laws are designed to prevent media from publishing material that could prejudice a fair trial. These laws empower judges to issue restraining orders or impose fines and other sanctions when coverage oversteps acceptable boundaries. In several instances, UK courts have halted the publication of headlines or online posts that risk undermining the presumption of innocence. These actions underscore the judiciary's commitment to preventing trial by media. UK judges have consistently asserted that while freedom of expression is vital, it should not come at the cost of fair judicial process. Key legal precedents illustrate how the balance has been maintained. Cases where judges have taken proactive steps, such as issuing guidelines to media outlets during critical phases of high-profile trials, demonstrate the proactive stance the courts take. The strict enforcement of the sub judice principle in the UK ensures that media commentary remains cautious during active litigation. Overall, the combination of clear legal provisions, active judicial interventions, and the enduring culture of restraint among media professionals has made the UK a strong example of how to manage media trials effectively. The UK system, however, is also not immune to challenges, especially in a rapid evolving digital environment. But its foundational principles provide a sturdy safeguard against undue interference in the legal process. In the United States, the judicial response of media trials is framed by constitutional guarantee of free speech under the First Amendment. This protection creates a unique challenge: how to balance robust free expression with the need for an impartial trial. One of the most illustrative cases in this area is Shepard versus Maxwell. In this case, the US Criminal Supreme Court found that intense prejudicial media coverage had compromised the defendant's right to a fair trial. The court's ruling underscored the tension between the First Amendment's protection of free speech and the necessity of safeguarding judicial proceedings. The decision led to significant reforms in how judges manage media coverage, including the implementation of stricter courtroom protocols and the use of sequestered juries. Judicial management of media influence. American courts have since developed various techniques to mitigate media influence, such as jury instructions, enhanced instructions to juries regarding media exposure, and necessity of regarding extraneous information in camera proceedings. In some high-profile cases, sensitive evidence or discussions are held in camera, behind closed doors, to limit public exposure and its potential prejudicial effects. The US experience illustrates that while the First Amendment creates a high threshold for restricting speech, There exist judicial tools and remedies such as careful jury selection and in-camera reviews that can help temper media influence. These methods provide a blueprint for balancing the competing interests of free speech and fair trial rights, despite the absence of robust statutory limits, similarly to those found in the UK. Beyond the UK and the US, other common law jurisdictions offer additional perspectives that enrich our understanding of how media trials can be managed. Australian courts have adopted a balanced approach that incorporates elements of both the UK and the US models. There are strict contempt provisions, yet a strong cultural commitment to free speech remains intact. Australian judges have times used media bans in specific cases to protect trial integrity. Canada, similar to US, places significant weight on freedom of expression. However, Canadian courts have also taken a proactive approach in managing media coverage, issuing detailed guidelines on how media should report on cases under trial. The judiciary has on occasion imposed publication bans to preserve the fairness of proceedings. While each jurisdiction faces its own unique challenges, the overarching lesson is clear. A carefully calibrated balance is necessary, whether through statutory rules, judicial discretion, or a combination of both. The goal is to protect the fundamental rights of the accused while still allowing a free and open press. As we conclude this comparative analysis, reflect on the following. Diverse approaches. How do UK's strict contempt provisions and judicial oversight compare with the US? Emphasize on balancing First Amendment rights and fair trial safeguards. What lessons can be drawn from these jurisdictions that might inform reforms or new approaches in our legal framework? In an era of digital media and global communication, how might a system evolve to adapt these comparative practices effectively? This broader perspective not only enriches our understanding of the global landscape in managing media influence on legal processes, but also challenges us to consider how our own regulatory measures might be strengthened and modernized. Beyond domestic legal frameworks, international bodies and legal commissions have provided a wealth of recommendations. These global insights not only underscore best practices in maintaining ethical journalism while safeguarding judicial independence, but also offer a blueprint for reform that could be adopted to our context. In this segment, we explore three key areas. One is guidelines from the International Bar Association. IBA, which represents legal professionals from around the world. The IBA has developed a set of guidelines intended to help media organizations navigate the delicate balance between robust freedom of expression and the imperatives of judicial independence. The IBA guidelines stress the importance of thorough fact-checking, avoiding speculative commentary, and maintaining an objective tone, especially in legal matters. They suggest that media should always ensure that reporting on ongoing trials is based on verifiable information. Refrain from publishing commentary that might influence public opinion prematurely. Observe the sub judice principle by minimizing editorializing when cases are still under active judicial consideration. What's its applicability in India? These recommendations are particularly pertinent for India, where media trials have sometimes overshadowed the evidence-based judicial process. Adapting the IBA guidelines could mean encouraging regulatory bodies and media watchdogs to adopt these principles or practices in their codes of conduct, facilitating training sessions and workshops for journalists to familiarize them with these international standards, instituting self-regulatory measures within media organizations that align with these guidelines, thereby building a more balanced framework for legal reporting. Next, we review global case studies that illustrate how various jurisdictions have successfully balanced free expression with the right to a fair trial. Several countries offer instructive models, successful balances in the United Kingdom. As we have discussed earlier, the UK's strict contempt of court provisions and active judicial oversight have kept media interference in check. The practical measures taken during landmark trials demonstrate that well-defined legal restrictions can coexist with the free press. In the US, the combination of robust First Amendment protections with judicial tools such as sequestered juries and in-camera procedures provides another model. These techniques have been successfully used to mitigate media influence without unduly compromising free speech. Both Australia and Canada have developed hybrid approaches that blend statutory regulations with proactive self-regulation by the media. For example, Australia's occasional media bans during particularly sensitive trials and Canada's publication bans offer useful lessons in mitigating prejudicial reporting while preserving overall media freedom. The common thread in these case studies is a willingness to innovate and adopt regulatory mechanisms as new challenges emerge. Each country's experience offers a set of strategies that can be tailored to fit the unique social, technological, and legal environment in India. Finally, we ask the crucial question: what can India learn from these international perspectives and successes? India could benefit from a more systematic integration of international guidelines into its own regulatory framework. This might involve revisiting and revising existing laws to include clear definition of prejudicial content, enhancing judicial oversight by mandating specialized training for judges and media professionals on handling high profile cases, creating a dedicated oversight body or an independent media tribunal to monitor and enforce ethical media conduct. In today's digital world, India must also consider how technology can assist in rapid verification of news and monitoring of media content. Implementing technological tools that align with international recommendations can help track breaches in real time. Another key takeaway is the necessity of collaboration. Establishing regular forums that bring together legal experts, media professionals, regulatory authorities, and civil society can help maintain an ongoing dialogue. This continuous engagement is crucial for evolving standards that keep pace with technological advancements and emerging challenges. Finally, public policy must reflect a balanced approach that protects both the freedom of press and the right to a fair trial. Educating the public about the importance of responsible journalism and judicial independence is essential. Ultimately, these reforms should aim not just at penalizing misconduct, but at fostering a culture of integrity and accountability across the media spectrum. As we conclude this international review, the key takeaway is that while every legal system has its unique challenges, the underlying principles of responsible reporting, judicial impartiality, and balanced regulations are universal. The guidelines of the IBA, combined with successful practices observed in the UK, USA, Australia, and Canada, provide a roadmap for enhancing our own media regulations. These insights will now form the basis for our discussion on future reforms later in lecture, as we consider how India might adapt and adopt these strategies to create a more resilient and ethical frameworks for media reporting on judicial proceedings. Having established a global context, we now turn to solutions and recommendations for a future where media and justice can coexist harmoniously. We have seen throughout our discussion media trials, while sometimes rooted in good intentions, can have unintended and often severe consequences on the judicial process. Recognizing this, various legal experts, parliamentary committees, law commissions, and media ethical bodies have put forward a number of reform proposals aimed at restoring the balance between freedom of expression and the right to a fair trial. Let us now consider some of the most prominent proposals and examine their feasibility, intended impact, and challenges in implementation. One of the most discussed reform proposal is the establishment of independent media tribunals or press ombudsmen, particularly to deal with legal and ethical violations in high-profile cases. These tribunals would act as quasi-judicial or advisory bodies with the authority to receive complaints against prejudicial reporting, call for accountability, and recommend penalties or retractions. Such a body could be composed of retired judges, senior journalists, media law experts, and public intellectuals to ensure balance and independence. Its jurisdiction would include summoning media organizations to explain content that may prejudice sub judice matters, issuing directives for corrective measures such as public apologies, retractions, or content takedown in extreme cases, forwarding cases to courts when contempt or defamation thresholds are crossed. Let's compare some models of this. In South Africa, the Press Council includes an ombudsman who mediates complaints before escalation. The UK's Independent Press Standards Organization acts on a violation of the editor's code of practice. These models could inspire the design of a robust Indian counterpart that functions with both efficiency and autonomy. This body could provide a faster non-litigation mechanism for redress and ensure that the rights of the accused and the integrity of the trial are preserved without overburdening the courts. Another powerful reform suggestion is to expedite the resolution of cases that are prone to intense media attention. One of the reasons media trials gain traction is the time lag between an incident and its legal resolution. In this vacuum, speculation and media outrage fill the space. Shortening this window could minimize damage. Let's take some suggestions. Fast-track courts, establishing dedicated benches to handle media-sensitive cases with strict procedural timelines without compromising the thoroughness of the trial. Courts can preemptively identify cases at risk of media interference and adopt measures such as in-camera proceedings, sealing of certain documents, or partial media embargoes. Some experts recommend the appointment of official spokesperson or judicial communication officers who can issue verified statements or stated updates on ongoing trials to reduce misinformation in the public domain. So there are some challenges also. Speed must not come at the cost of thoroughness or fairness. Moreover, prioritizing media-sensitive cases must not undermine the principle of equal access to justice. Finally, and perhaps the most immediately actionable, is the proposal to strengthen and enforce existing ethical and legal frameworks, especially those issued by regulatory bodies like the PCI, News Broadcasting and Digital Standards Authority, and statutory frameworks like Contempt of Courts Act 1971. Here, the PCI guidelines, while comprehensive, real enforcement power. Its authority is largely mandatory and its reprimands are not legally binding. Digital media and social platforms, which are now dominant sources of information, often operate beyond the traditional regulatory ecosystem. What are the proposed enhancements? Let's amend the PCI Act to give it teeth. With the power to impose fines, suspend press accreditations, or refer matters to courts in case of gross violation. Ensure compulsory compliance with ethical standards across broadcast, print, and digital platforms, creating a unified code under one umbrella, possibly modeled after the IBA recommendations. Develop collaborative enforcement mechanisms involving both regulator and the judiciary, enabling prompt responses to violations in high-stake cases. The role of technology in this enforcement is massive. AI-driven tools and digital surveillance platforms can help regulators monitor compliance in real time, especially important given the 24/7 cycle of social media content. To sum up the reform proposals we have examined today, ranging from creating media tribunals to expediting court processes and reinforcing ethical guidelines, are not mutually exclusive. Instead, they must be seen as complementary tools in a broader strategy to preserve judicial integrity and media freedom simultaneously. Each of these reforms will require legislative will, institutional cooperation, and public buy-in. Both, most importantly, they will require a cultural shift where both the judiciary and the media reaffirm their commitment to the ideals of truth, fairness, and justice. Looking forward, the future of both our legal system and media reporting in India is not a matter of legal reform alone. It is about meaningful, sustained collaboration across sectors. The issues surrounding media trials and their impact on the right to a fair trial cannot be resolved in silos. They demand engagement, dialogue, and commitment from the stakeholders. Bridging the gap between journalists and legal experts, let's begin with the urgent need to bridge the gap between media and the legal community. Often misunderstanding arise not from the malice but from ignorance of legal nuances, procedural sanctity, and judicial ethics. Imagine a scenario where every newsroom has access to legal advisors who help interpret judgments or guide journalists through complex legal terminology. Consider how much more informed public discourse would be if legal experts participated regularly in editorial briefings, not to control narratives, but to provide clarity. Some pilot initiatives have already demonstrated promise. Workshops hosted jointly by bar councils and media organizations have led to enhanced mutual understanding. For instance, in few metropolitan cities, media houses have collaborated with retired judges and legal scholars to hold periodic roundtables. These conversations promote shared perspectives and have been even resulted in voluntary adoption of self-restraint in reporting. By formalizing such collaborations through institutional partnerships, university exchanges, or even legal education modules tailored for journalists, we can help shape a media culture that is both assertive and responsible. Now let's turn our attention to the public, the most significant stakeholder in a democracy. In today's hyperconnected world, media content reaches millions within seconds. The problem isn't just what is reported, but how it is received. An uninformed audience is more susceptible to bias, more likely to mistake sensationalism for truth, and less likely to critically evaluate narratives. This is where media literacy plays a vital role. We must promote public education campaigns that teach citizens how to discern credible reporting from speculative storytelling. Schools and colleges should incorporate modules on media ethics and legal rights, particularly focusing on the presumption of innocence, the stages of a criminal trial, and the dangers of public prejudice. Public awareness efforts could be amplified through partnerships with NGOs, tech platforms, and influencers who can speak in the language of the people. Short videos, short media campaigns, and civic engagement workshops can empower citizens to question, to think, and to resist falling prey to media-driven verdicts. An aware citizen is not just a passive consumer of information. They become a watchdog against misinformation and a pillar supportive of fair justice system. Ultimately, real change requires the participation of everyone. Judges must continue to speak through their judgments, but they can also participate in public legal education. Legislatures must update existing laws and reflect the challenges of the digital age. Media houses must develop and enforce stronger internal codes of ethics. Regulatory bodies must be empowered not only with rules but with real teeth to enforce them. And we academics, lawyers, journalists, policymakers, and concerned citizens must form coalitions that push for timely reforms, that review case outcomes and media practices together, and that hold each other accountable in the spirit of democratic coexistence. Think about how powerful it would be to have a national forum for judicial and media ethics, where cases of public concern can be discussed, reviewed, and lessons drawn without adversarial finger pointing. This is not just desirable, it is necessary. As I close this segment, I leave you with a vision where courts are swift and impartial, where media is free but not reckless, where citizens are informed and not inflamed, and where the rule of law coexists peacefully with the right to know, a vision where legal systems and journalistic values complement one another rather than clash. And above all, a vision where no individual life is derailed by a rush to judgment, either in the court of law or in the court of public opinion. You in this room are just not just observers of that future, you are its architects. As we wrap up, let me just take a few minutes to highlight some of the key ideas that emerge from our dialogue. One is balancing rights and responsibilities. There is a need to preserve media freedom, but with clearly defined boundaries during the pendency of trials. We discussed the idea of introducing time bound restrictions, not as censorship, but as temporary safeguards to protect judicial impartiality. It has been proposed innovative hybrid models that combine self regulation with judicial oversight, allowing for flexible yet accountable frameworks. Two, harnessing technology with care. I was especially encouraged by suggestions around leveraging AI, data tracking, and content moderation tools to detect and curb prejudicial reporting in real time. These ideas reflect a forward thinking mindset, one that accepts the inevitability of technology, but insists on using it ethically and responsibly. Third, reform through collaboration. Perhaps the most compelling theme today was not no single institution can solve this problem alone. It will take a coalition. Courts, media houses, lawmakers, civil society, and yes, future leaders like you. It has been emphasized and suggested that public education and media literacy is the foundation. If public can recognize media bias, sensationalism loses its power. Justice then has a fighting chance. And here's the final thought. We begin today with a paradox. How can two pillars of democracy, the judiciary and the press, sometimes work at cross purposes when both exist to serve the public interest? Through the lecture, we have unraveled that paradox, explored its dimensions, and looked to both the past and the future of the answers. The issue of media trials is not going away, but neither is our resolve to meet it with intelligence, integrity, and innovation. So, as you walk out of this, whether you are a lawyer, a journalist, a policymaker, or a concerned citizen, I leave you to this charge. Be critical, be responsible, be brave. Demand accountability where it is due. Defend freedom where it is threatened, and above all, uphold the truth because justice depends on it. Thank you for your attention, your time, and your commitment to shaping a fairer, more informed India. This concludes our lecture. This is Amod Bidhuri. We will meet again in the next hearing. Thank you.